Well, hello, everybody. Really excited about NFT.NYC this upcoming June. I'm glad to be here with David. David is a lawyer that specializes in many things outside of the NFT world, but certainly has been faithful to serve some of the folks in our network. And he'll be speaking at our event, and I look forward, David, to learning from you there. But can you please introduce yourself and tell folks a bit about what you do for people in this industry?
Sure. My name is David Boag. I am an attorney, founder of Boag IP, which is we call it a boutique law firm, meaning that it's on the smaller side, but we still provide like a very robust client service. And we focus on a lot of things, but new and emerging technologies in the past few years has been huge. And NFTs since, well, this will be, I think I've been to every NFT.NYC since it started. So I'm looking forward to that, certainly.
Yeah, I remember it was like 150 of us at the PlayStation Theater in 2019.
Great.
And I remember you were there with us, and that was the very beginning. So you're from the founding attendee and seeker back in the day.
Seen it, yeah, balloon
That's
to
right.
It's really something now.
It is. Can you define intellectual property, and is your definition of IP any different in a decentralized Web3 NFT world than it had been in the past with more traditional businesses?
So intellectual property, what we normally say, it's some sort of bundle of rights. It's a bundle of rights that the government gives you to protect something, and that something can be a novel idea, an invention, it can be creative expression and a copyright, it can be a brand, but there's some formalities associated with it. You go to the government, you get some sort of registration or whatever, and in exchange for that, you get these exclusive rights. Now, these types of rights have existed for a very, very long time, predate the internet, the atomic age, everything else. The same rules generally apply. I mean, the fact that it's decentralized, that certainly makes it very interesting and exciting, and a lot of the technology is certainly new, but the way you go about protecting yourself and the way you go about avoiding infringing other people's rights, that's all the same, and the same rules more or less apply there.
So how do you deal with IP when you're counseling people if they've hired you? And by the way, none of this is legal advice, party people. We're just having a conversation. How do you deal with it if it's an individual compared to an organization? So for instance, a record label compared to a famous artist or musician, and they're coming to you and saying, hey, this is our plan for what we're going to do with NFTs. And how do you counsel me, artist, or us, record label? Is it a different conversation for a corporation compared to an individual person?
Uh-oh, you broke up on me there.
Well, I can still hear you. Hopefully I'm still coming through. I was asking about if there's a difference in terms of how you counsel organizations compared to people.
Well, you broke up on me there for a second, and I was just staring at your frozen image. But what I gather from what you're saying is, how do you deal with advising an individual versus some sort of larger artist corporate entity? And I still think the same types of rules definitely apply. I mean, the resources you might have access to are a little bit different, because a larger company certainly is, there might be more at stake, and they're going to put more into it. But it's basically the same either way. The idea is that, one, you want to make sure that you don't bump into someone else's rights. That's, I think, the primary rule when it comes to IP issues for anybody. And the second thing is, if you've got something that you want to protect, go out and do the formalities that you need to protect it, get your exclusive rights. Whatever you plan on doing with it, you usually only have a certain time to do that.
Is there a heavy weight on research in the very beginning? Is a lot of the engagement have to do with doing research to see what's already out there in terms of other people's rights that you don't want to violate?
You broke up on me again, Ian.
How exciting. Yeah, this is an exciting interview. So what I was asking about is how much weight is on research? How much weight is on research in terms of
definitely doing research? There's certainly a lot of DIY work that you can do in the patent space, for example, making sure that you don't bump into someone else's patents. You can take a look and see what other people are doing. You're going to want professional advice before you make any real decisions on whether or not you infringe, but you can certainly check the landscape and and get smart on it. And the same goes for brands, protecting your trademark. Take a look at what other.
Yeah, that came through. Apparently one of us have a weak internet signal, the joy of technology. When you're at the NFT.NYC event, it's grown so much over the years. How is the development and kind of ways that people are dealing with IP in this industry changed over the last few years? Still not coming through. How exciting. How exciting.
I'm plugged into wired Ethernet, so I'm hoping that this is working.
Yeah, no kidding. It says mine's working too, so we'll blame Zoom this time.
I'm happy to blame Zoom. So you were saying when at NFT.NYC in person, and then I lost you.
Yeah, so how has it changed? Because you've been a part of the community for 4 years. So how's the IP conversation changed over the last 4 years as things have become established and money's gotten involved?
Yeah, this has become big business. Like the way my metric for it is, if your mom knows what an NFT is, it's mainstream now. Like, and the same thing, I saw this with cannabis a few years ago. We do a lot of work in that field as well. The conference has grown so much, and it just naturally attracts more money is coming in, more investment. You see a lot more. Not just the big law firms are there, which you didn't see 2 or 3 years ago. A lot of like the big white shoe firms, but you see a lot more people like us, the boutique firms that work with, smaller clients, are a little bit more accessible. You see a lot more of us, not just on IP, but on all different aspects, tax, regulation, insurance, like you name it. So it has certainly changed a lot. There's a lot more interest. People take it more seriously as an industry.
Do you see innovation in IP because it's new industry, new approaches? Are people being more innovative and having more diverse approaches to IP in this industry than you had seen in the past?
I think the approach is a lot the same, in terms of, you've got a novel, non-obvious idea that's patent eligible. You go to the patent office, you secure rights in it. That's the way we've always done it. But there's a lot of other interesting things that people are doing using NFTs to, package IP, like put together a portfolio of patents associated with that NFT. You transfer that. Assignments happen with a smart contract. Selling intellectual property rights, selling a whole portfolio bundled with, information about the history of it or prospective infringers that automatically transferred. I've seen some really interesting and new things that people have done with that.
When it comes to an artist creating art, let's say a painter doing a digital painting or a musician creating a song, there's questions. Should we give non-commercial rights or commercial, like non-exclusive commercial rights? Or what if I want to give full commercial rights away? So are there any thoughts that you have around, don't give this much away, you have to retain this as the creator? Or is there no rules? And it's like, hey, if you want to give that level of IP away or share that level of IP, that's fine. Is there a standard by which people should think through IP utility attached to an NFT and a smart contract?
Well, I think that it really depends on what you're trying to accomplish, because there are certain areas in the field where you're looking, like Uniswap, SushiSwap, exchanges, different platforms, they're looking to get people not just to adopt it and use their platform, but to develop and innovate using their tools, so it creates, kind of a de facto standard. For companies like that, you want to give pretty broad, almost, open source rights in a lot of cases to that. You're also running a business, you're not running a foundation or a charity, so you want to make sure you hold something back. So I think some companies have figured out a way to do that, where they, separate the tools from their core model. And then, Uniswap, for example, kind of pulled things back with version 3. They went back to a model where you can use this, but you got to wait 4 years to get a free license. If you do it commercially, we want a cut of that. We want a license fee right now, but we'll dedicate it to the public. And the advantage of that down the road is that, it encourages people to develop on it, knowing that it's going to be open source someday. It's not yet. Whether that, bears fruit is another option. When it comes to, the actual content, what you're packaging, an NFT is basically a container. what you're putting on there. If you're talking about a piece of music or art or anything like that, I think the same rules would apply that you're doing with anything else. If you want to make this mass market and see it everywhere, then you want a looser set of rights. But if you're, if this is the one of a kind JPEG, Beeple, New York Times article, whatever, kind of things we've heard of, you want to make sure that that's kind of buttoned up a lot better with a smart contract and you're not giving away the store.
With IP, there's patents, trademarks, copyright. It's not limited to that, but is there more of an emphasis on copyrights and trademarks over patents? Because it doesn't feel like a lot of people in the Web3 decentralized world are focused on patenting things as much as other areas. So are there certain areas that have more focus and other areas that have a lot less?
I don't know if I've ever thought about it like that as to what, there's certainly, when it comes to what you're putting in the NFT, there's certainly copyright issues that come up with the actual media that you're associating with it. With patents, though, I think there's a lot of activity, and you're right that there is a mindset of, we don't want to patent this. This is for everybody, and I think that's great, and I think that promotes NFTs generally, and it promotes standards. But someone's going out there, and there are patents being filed like constantly every day, thousands of patents applications. So someone's doing this. It's kind of a land grab, and we all know there's IBM is super active in distributed ledger computing, and they're applying left and right for things. We've seen Nike. There's a lot of corporate entities. So even if you're not, other people might be. So it's still something to keep an eye out for. And then, there's also trademarks that you mentioned. That certainly comes up a lot. And people are that's always going to be a thing to set yourself apart and, protect your core brand. That's always a good idea to make sure that your house is in order there.
When someone wants to engage with a law firm, they might think to themselves, well, I got to hire an individual or a team to help me with this project, make sure we don't screw up and that we're legally compliant. What's the advantage for projects and teams and companies in this Web3 world to have a law firm on retainer, so they have somebody in their corner at all times? Can you maybe explain to folks that maybe haven't done that, maybe they have new success with their NFT project, and maybe you could give a little counsel on what's an advantage of having a law firm that's kind of a partner to you that you have a consistent relationship with?
Right. So, it's like a lot of things. Like, I've been going to the same GP, the same doctor for 10 plus years, because I know he's not billing me every month. It's expensive when I go, but he's not billing me every month I don't go. And when I call, he calls me back and can answer questions for me. And sometimes he charges for that. The model is the same with law firms. It's very helpful to have someone who knows this stuff and knows your company that you can talk to periodically. It's not always going to be free to do that, but you don't need to put a $10,000 retainer down necessarily in order to have that relationship. The legal world, like every other professional service and lots of industry, has changed dramatically over the last 10 or 20 years. People do flat fee models. There's lots of different ways to do things. So I think it's very useful to have somebody who knows you, your company, and that you can actually get in touch with when you need them on call.
Is there a resource that you maybe refer people to if they want to do, some investigation? Is there, maybe you have a site or a blog, or maybe there's a certain website that you say, well, why don't you go here? This is a great place to kind of get your 101 information as people try to formulate how they want to attack these different issues.
Yeah, I mean, there's a lot of different resources. The Patent and Trademark Office, USPTO.gov, Google Patents. Those are both, easily digestible resources for the basics of protection. There's lots of good blogs out there. We just redid our website last year, and we're steadily building out the content. But boagip.com, boagip.com, we're more and more adding more resources on that, with a focus on this sort of technology.
And is it ever too early? So if somebody has an idea and it's still at idea phase, they haven't recruited a team, they haven't gone to market, is it ever too early to reach out and get legal counsel? Or is it preferable that they do it before they get too many things in motion?
I think it's a good idea to, early early is best. I don't think you can ever be too early. We talk to people all the time whose ideas aren't fully baked, as they would even admit. But it's good because then okay, I haven't fully thought this through yet. Because there's certain triggers in IP law, like once you've disclosed something, you only have a year to patent it. Things like that people don't always know about, and lots of other requirements along the way, protecting yourself, making sure that your employees don't end up owning the patent, and all these little traps that can come up along the way. So it's good to get that stuff in order from as early as you can.
Well, I'm grateful that you jumped on with me. Sorry for the internet. I blamed Zoom, but it's probably my fault. I live in a treehouse, so the internet's
fine. It's fine. If we don't edit it out, it makes for a much more real conversation.
That's right. This is real.
How most Zooms are with people now. I did a Zoom with some colleagues in China last night for my car. So at 9 o'clock at night, because my wife and my stepson were sleeping. So
right.
That's what the reality is now. So
yes, that's right.
Well, I'm glad I got to see you in the treehouse. Thanks for having me.
And I really got to have you, and I look forward to seeing you in New York next month.